Thank you for joining us. Like Michael said, today is conducting the mediation. Okay, and my name again is Jeff Zano. I'm your moderator for today. This webinar is part of the Financial Poise Alternative Dispute Resolution webinar series. Slide 8, and I'll jump to it, gives you a summary of the series. We're on number 2 in the series. We have 2 more to go. The next one's on June 24th, followed by July 22nd. But you're here today for the conducting the mediation one. And slide 6 gives you a summary of what we're going to talk about in this episode today. Speaking of the slides, you should understand from the get-go that we may not step through all the PowerPoint in order, nor will you have to listen to us read any of the slides. This webinar, like all Financial Poise webinars, is a conversation, and we'll have a great conversation with these esteemed panelists. Keep the PowerPoint handy, however, because I will try to indicate from time to time what slides our conversation is touching on as we proceed so you can take notes. Slide 4, and I'll go to slide 4, is the disclaimer. Please note that our PowerPoint is for informational purposes only. It should not be considered legal, financial, or other professional advice. Okay, I'm going to introduce our panelists now. One of them is missing, but should be here shortly. But we have Leslie Burkhoff from Mort, Hock, and Hamroff. Leslie is a partner with the firm where she serves as chair of the firm's dispute resolution practice group and is the former co-chair of the firm's creditors' rights and restructuring department. Also joining us later today will be Elizabeth Champnoy of Champnoy Dispute Resolution and Management Services, Inc. Liz is an attorney, consulting expert, independent full-time mediator, arbitrator, and trainer based in New York City with 25 years of experience in the field of alternative dispute resolution. Then we have Björn C. of Snell Wilmer of Denver. Björn is a business litigator who represents individual clients in complex intellectual property and commercial matters, and his clients have sought his guidance in disputes related to failed business ventures and disputes among business partners, shareholders, and directors. Again, my name is Jeff Zano. I'm the vice president of the American Arbitration Association's commercial division based in New York City. Feel free to read more about us on slides 31 and 35 with some nice pictures of all of us. This webinar is a production of Financial Poise. To sign up for their great free weekly newsletter, go to financialpoise.com/subscribe/. Again, financialpoise.com/subscribe/. If you are attending the live premiere of this webinar, you can submit questions using your web portal. If you are watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com, info@financialpoise.com. Just include your question and the name of the webinar episodes, and we will do our best to get you some answers here. Okay, we'd like to thank our co-producer, and I'm going to go to slide, is our co-producer, sorry. Right here is the National Review, okay, a premier legal website. Okay, the National Review has been around since 1888, and we want to thank them for being a co-producer on this. Okay, well, we're going to get started, and I'm going to tell you what we're going to go over, and then I'm going to turn it over to Leslie. Okay, so today we're going over preparing for the mediation, joint session versus caucus, opening statements, working with the mediator, risk analysis, finalizing the deal. Now, I did say we weren't going to read the slides, but I had to do that one on that one. So with that, I will turn it over to Leslie for initial session.
Wonderful. So when we're talking about initial session, and by the way, we are going to pivot a little bit between what's going to happen during the mediation itself and sort of a little bit of things that go into getting ready for it, different than we did last time, which was really full preparation. So in an initial session, it's the first time that you're meeting with everybody. There should be, the mediator has some level of opening. Joint sessions, which is when all parties are together, don't always happen as frequently. There are some mediators that only do joint session, never let anybody out. There are some mediations where parties don't ever want to get in the same room. And you effectively cover whatever I'm talking about now privately. So private caucus versus joint session or joint caucus. When I can try and get people all together, even if it's just for what I call the rules of the road, it's easier. I think it's nice for people to meet one another, put names to faces or faces to names, whichever way you want to say it. I like to be able to be sure that everybody has heard the exact same thing, although I do have a cheat sheet I bring to every mediation. And I tell people, I know you maybe have done tons of mediations, 10, 5, maybe none. You're going to hear what I have to say, and I'm going to say it every single time because I want to be able to say, like any good litigator, I know that I said it during the session, not because I particularly remember saying it, because I do it as a matter of course in every single session. And why is that important? I want the parties to understand a couple of different things: how the process is working, what confidentiality means within the context of a mediation, what it means when they give me information, when I write it down, when I keep it, what I'm doing with my files, whether I'm shredding things, which I do, what I'm doing with my notes, how things are being exchanged, what they can and should be sharing. I want to make sure they understand everything for a variety of reasons, including I want to make sure that they're settlement focused, they are communicative, informative, and looking to try and get to a result if possible. So whether that gets done with a joint session, private caucus, or the hybrid approach, I'm going to make sure that happens. If we can go to the next slide, Jeff.
Oh, how often do parties refuse to go to joint session? Does that happen a lot? Or
I'm having a lot more of that. We know what it is. We know everybody's position. And the one thing that happens that I think they miss is, I don't force it because sometimes I know it doesn't make sense.
Yeah,
But sometimes the only time you're going to hear what needs to be said without the lens of your lawyer is when you hear it from the other side. So your client hears it from the other attorney. Quite frankly, I hear things differently. Think you're missing an opportunity to sort of state your position, ideally in a non-aggressive but settlement-focused fashion. And if you don't do that, you're missing something.
sure.
So the reluctance to do it, we don't want opening statements. They become adversarial. They only become adversarial if you're doing them wrong. So occasionally I have a mediation that's coming up where I got pushback from some of the parties, and all I wanted to do was sort of get everyone around the table. There's 8 different factions. Some of them want it, some of them want to be able to sit there, and I put my foot down and say, we're going to all sit together. I'm giving the rules of the road. I'm going to offer you the opportunity to speak, but I want you to consider the fact that if nothing good is going to come by what you're saying, keep your mouth shut. I said it much nicer than that, I promise you. But don't dig your heels in and bully the other side.
Sure.
So that's really, I think, important. So you jump the slide here. Oh, I jumped a slide, pardon me. Okay, so there's something that you have to think about. So if you are having this joint session, you need to give thought to whether or not your client should speak. I always encourage clients to speak. I always point out that they shouldn't speak. To the contrary, I defer to their counsel in that regard. But sometimes when your client speaks, they're showing the other side what kind of witness they're going to be. That can be a good thing. Conversely, it can be a terrible thing. Maybe you don't want your client opening their mouth at all. Also, at least in private session, the client really should be talking because that's their chance to talk to me, to educate me, to have their day in court. Other than in mediation, where it's not as controlled, the only time a client ever speaks is when they're on the stand or in a deposition. It's a very different analysis. It's a very different presentation. So I think it's really important to have them talk about it. And I think the other thing we have, making the most of the mediator's approach, you've hired me for a reason. I'm telling you things for a reason. I may be telling you them because I can't share what the other side has said to me. But if I'm asking you to do something, you should take a moment and say, she's got a reason for doing this. Maybe we should listen to her and I always say to them, you trusted me enough to hire me. Please trust me enough to pay attention to the signals I'm giving you. I'm not doing it for no reason.
Yep.
Um,
Okay, so preparing for the mediation, pre-mediation tasks.
Yes, actually, in future presentations, this thing should go first. This should be our
Should.
first slide. Should make a note of that.
So noted.
But this is when I get retained in a mediation, I will have these calls, or sometimes, I will talk to them. I'll tell them, sometimes it's jointly to just talk about the case and process, and sometimes it's one-on-one with me and the client and me and the lawyer, or just me and the lawyers. I'm going to talk about how the case is going to go, how I'm going to handle the session. I may reach out and ask them questions. I have mediations this week. I've spoken to a fair amount of the lawyers on these variety of mediations and raised issues. I have questions. I need you to answer them. I want you thinking about this before you come in the session. I want them coming in prepared. And I also may take them through things that I think are weaknesses or strengths. I will never, ever, if one side has said to me, you know, hey, they've got this issue, and it hasn't been shared. I don't share things that I don't advocate for lawyers. I don't educate them. So,
Sure.
you know, if there's a statute of limitations issue and you haven't caught it, that's on you. But I may go into the other side that it's going to hurt and say, hey, by the way, they haven't raised this yet. I'm not telling them, but they're going to wake up one day and realize that they have this argument. And you need to think about the fact that you have a problem with your case because of it. So I'll never educate someone to make them a stronger adversary, but I can use things that I see that they've missed to beat the other side and say, let me tell you something. They're going to figure it out. The court's going to flag it. That's fair game. But you have to be very, very mindful because you are not there. You're there to evaluate a case. You're there to test strengths and weaknesses. You're not there to educate them on things that they've missed if they're affirmatively can be used by them. It's a very fine line. And I've seen it misused and misunderstood by mediators because then you're becoming their counsel and that's not what you're supposed to do.
Not a good thing, yeah.
Yeah, and from the litigator's perspective, when we have these pre-mediation calls, I usually focus on issues that aren't already included in the mediation statement. So maybe some emotional aspect of this case that everybody needs to be aware of. Maybe some business aspect of this case that may not be obvious from the documents. So I wouldn't waste, as a litigator, I wouldn't waste too much time from my perspective on this call, kind of regurgitating everything. Most
Yeah.
mediators are great and have read the statements. Focus on, I'd encourage everyone to focus on things that are outside of those mediation statements.
Right. And that's the purpose of the call. I don't call them to, you know, revisit things. I may call them to say, I don't understand your argument, or I need more information, or have you thought about this? But I don't need them to tell me in that call what they've already told me, assuming they've told it to me the right way and properly.
Beyonce, have you ever had a situation where the mediator didn't do these kind of things and was unprepared when he or she came in?
Well, I haven't had the latter of being unprepared, but I have had plenty of situations where if I have a long established relationship with the mediator, sometimes we don't have the calls.
Yeah.
They can read my state. They know me well enough that from my statements, they can go, oh, okay, I need to give Bianca a call. There's some aspect of this that seems a little squirrely. Maybe he can give me a little more flesh to work with.
Sure.
But then there are other times they'll just drop me an email saying, hey, do we need a call? I'm like, I don't think so. I think
Yeah.
this is pretty straightforward.
Sure. So Leslie, you kind of covered some of this already a
Yes.
little bit, but you want to go, yeah, 2 slides on opening statements.
Yeah, let me just again, I think I covered a good amount of the fact that, you know, you're missing an opportunity here to set a stage for successful negotiations. But there are quite frankly some cases. I don't treat every case as one size fits all. There's somewhere I really know the lawyers or I know the arguments, and it's just not something that we need to do. What I will reserve the right, for lack of a better word, is to say to them, we're not doing it, but there's going to be a point in time I may bring you people together. And I may bring just the lawyers together because sometimes, you know, the arguments get to a point that me running back and forth, so to speak, doesn't make a lot of sense. I'd rather have a conversation with me in the room and let's just take this point of law or these facts and let's break it down and have a conversation, because it's just not effective all the time for me to go back and forth with shuttle diplomacy. It's better for them to talk with guidance and, you know, oversight about something. So again, I think if there's a mediator that, and there are some, and I've, you know, Jeff, you've heard them too. Nope, I
Yep.
always do joint sessions. The only way I go, you can't do that. Every case
Can't.
is different. Every case is
Every
different.
case is different, and it's the party's process. You
Yeah,
know,
right. That's the other point. It is their process, and I'll say to them, I can only make a recommendation. At the end of the day, it's your process. I'm a tool in a toolkit. I'm only there to guide. You can either listen to me or not. So.
Absolutely. Yep. So you kind of got that okay, covered. And hold on. kind of covered that a little bit, I think. Is that correct?
Catch up with you.
Yep.
Yeah,
Okay.
I do, yes, I think we covered this one.
Okay, so then I'll go to the next. And is that still you? I think it is.
Yeah.
Strategy when to utilize a mediation opening statement. Okay,
So, one of the things, and we didn't quite fully cover all of this.
okay.
I do think that I have seen a couple of lawyers, I have, especially in the restructuring context, firms that I work with regularly. They hire me all the time in these clawback cases. And so I'm on their panel and they could be doing 50 lawsuits or whatever it is. And some of them have become very skilled in a good way at being very effective in this process. So I have seen some of them take the defendant, we have an opening session, and they really, especially if they represent a fiduciary, will explain to them, look, I'm sorry we're meeting this way. You understand I'm carrying out an obligation under the bankruptcy code. And they can do it very neutrally. And sometimes they diffuse anger. And there's a respect that's given to, I'm sorry you're being sued. I'm sorry this is happening. I have a job to do. I understand that you're the recipient of this. Let me explain what we're looking at. Let me explain the process. And suddenly they're not this amorphous bad person just coming after them for money. There's a different understanding here. It's also sometimes it's important there because there is no pre-existing relationship between the parties, but it's even more important sometimes when there is a relationship between the parties. Sometimes it's an ability for the two people that are fighting to just maybe take it down a notch and say, look, we don't agree. This fell apart. I'm sorry that you're upset with me, or sorry, whatever it is. You can use it sometimes to just even out emotion. And anyone that says there's no emotion in business disputes he's never been in a business dispute. I'm sorry, it's the silliest thing. Oh, it's not family law, it's not sexual harassment, there's no emotion. Are you kidding me?
Oh, it's family law. No, but it is family law sometimes. Sometimes we see father and sons, two brothers.
It's right. It's a fight over a closely held business.
Yep.
But even then, I do a lot of secure lending work. Sometimes I've got a lender and they're really ticked off that the other side's defaulted on this loan because they fought for them to get the loan. They took them to the approval committee and suddenly this guy or gal is stiffing them. And it's it's a black mark on their record. There is emotion there.
Absolutely.
I think when you simply say it can divide people, you miss the opportunity to maybe reach somebody.
Sure.
So, to that point, know who you're talking to, recognize it as an opportunity to be heard. Also a way to present it differently than it's going to look in a set of papers,
Sure.
I will say that we don't do, at least in the Denver market, many opening statements, only because I think a lot of litigation attorneys don't know how to do an open statement outside of the litigation context.
That makes sense.
Yeah, and
and that can
I've
really
had
go to
some
mediation.
I've had some bad experiences. In one time, I started doing an opening statement in a mediation, and literally it was like I was doing this to a peanut gallery. Opposing party and attorney started objecting or interjecting their comments. I'm then they go, well, this is not going to go well, and it didn't go well. Yeah,
it's an art form. I don't require it, like I said, but sometimes if you know how to do it, it can be incredibly effective.
that's right.
In the right case. Won't work in every case either.
No, you're absolutely right. Yeah. So
I think we've covered this.
yeah. Okay. And I think is this still you? No.
Nope,
That's you.
Yeah, when it comes to who should speak, in my personal experience, I rarely let the client speak. Rarely let the client speak. And I've done it only a few.
Private and in joint, or
I'm
even
sorry.
Is that also in private with the mediator? You won't let them speak?
Oh, I'm talking about just the joint.
Oh, a joint. Okay,
just the joint. Just the opening statement.
Yes, that makes sense. Okay.
Yeah, I've only done it a handful of times, and it's never really met with much success. But the factors that I consider is will the client speaking inflame the situation or would it improve it? The other factor I would think about is if I think my client is just a great witness and the opposing party has not deposed them, and so they don't know how charming he or she is, maybe I put them up to say, okay, here's some few things to think about. So then I throw that out there. Now you have to be careful because even though you're not in the court of law, um, I still don't want anybody on my side making any misstatements about the facts because that hurts your credibility with the mediator.
Sure.
And I care what the mediator thinks about me and my client. And if this case is not emotional charge, and to your point, Leslie, I had the one great client that I had. It was the other side was took the case extremely personal. It was just business on our side. So he said, let me just apologize in the beginning and then we can go into our separate rooms. And he did that. And I thought it was quite effective on the opposing counsel. Now, the opposing party still was too emotional to really even accept it. And kind of through our mediator, we learned that he was challenged the veracity or the sincerity of it. But I thought it was worth the effort, and we earned some credibility with at least opposing counsel. And there is no requirement that a client needs to speak. So during opening statements, so I do that. It's very rare that I do opening statement. It's even more rare that I let the client speak.
Well, quick question on that. On letting the client not speak. You say you usually don't let the client speak. What if the other opposing counsel lets his or her client speak? Does that make it different or not?
I make the decision regardless of what the other side states.
Okay, got it.
Yeah, I mean, if I'm driven by that, that's more an analysis that I would say I put into court, and so I'm not sure that should ever be considered. If your client wasn't good enough for an attorney to say, hey, I think he or she would be great in front of the mediator and opposing side, it shouldn't matter whether the other side does it as well.
Yeah. But
Yeah.
sometimes you get pushback from the client. The client that wants to speak, who wants to be, you must.
I get pushed back from the client on many aspects, but yeah, I do. I do. And actually, as a litigator, it's a great opportunity to have my kind of first uh, uh, blunt conversation about my assessment of them as a witness. And they
Sure.
need to know that sooner or later. So I've had clients where I said, listen, between you and me, you need work, and the mediation is not the place that you need work. You need to show your witness flaws. Let me work with you later and prepare you for a hearing, prepare you for a trial, or prepare you for your deposition. But right now, I don't think you. I think you come off too antagonistic. You seem to always you basically filibuster the whole subject, and it's not going to help anybody other than piss people off.
Sure, absolutely.
The one thing, and I haven't seen it that often, but there was one case where it was the fiduciary bringing the suit. So they, again, didn't have the pre-suit information. The other side let their client speak. When they left the room, the plaintiff fiduciary looked at me and said, we can't let that guy take the stand because we can't answer as he has the knowledge. He is an incredible witness. He's just going to be able to, we're not going to be able to fill the gaps.
Yeah.
And it ended up helping for purposes of settlement. It was a very smart move for the lawyer that knew his witness and knew how well. And it was interesting because the lawyer just basically said, Bob, whatever his name was, tell the story. And Bob did. And Bob was amazing. And I just sat there and went, yep, that was a great move. But it's unique, doesn't happen that often. And so all I would say is just for those that are in the area, just don't dismiss it out of hand. Maybe the way Byung-Suk does, make an evaluation. I think the problem is people go, no, I'm not doing that. No, they shouldn't do that just by rote. And that's where the mistake is. Just think about whether or not it might be effective because, unlike court where motions go a certain way and the balls and strikes get called only certain ways, this is a lot more fluid and you have a lot more flexibility. And by the way, nobody says at some point during the process, and I have had this happen where I've made a determination, maybe we didn't have an opening session, and I've said, you know what, I've read the temperature in the room, and I've said to someone, I really think if you guys sit down and you talk about this, you're going to move a needle here, because I've realized that they need to hear an apology, or they need to hear an explanation, or they need to have some deference paid to them. And a
Sure.
good mediator can sometimes recognize that that really might go a long way. So
Yeah.
again,
And
it's,
as a good mediator as you are, you must read body language too. You must be
oh, you
really,
have to read body language.
yeah, you must be really good at that.
That's the problem with Zoom. I've gotten good at Zoom, but you miss a lot of it. You can
Yeah.
misread body language on Zoom. And
Well,
I,
that's, and I was going to bring, I mean, I think it's later on in this slide deck, but, and do you do in person or mostly in
I
person?
prefer, if I can, I prefer in person. I have a lot of them that are by Zoom because in the clawback arena, the dollars and cents, and you may not need it the same way,
Yep,
but when I get into much more complicated, multi-party, matters, there really is validity in being in the same room with people, even if they're communicating with me, because as I say to them on Zoom, you're looking at a dot in the screen. You look at that dot in the screen for how long? You can't stare at it. And I will even say to them, please recognize that I'm not being disrespectful to you. I'm hearing everything you say. But if I move back so you could actually see it, I'll become tiny. So I'll have I keep a binder, I have a notepad, I have my computer up. I may have people messaging me or I'm pulling up documents that I've saved. And I said, so I'm not playing Candy Crush, I'm not doing other work, but I
sure.
can't just look at you the whole time. I have to look at other things. And I will say to them, and I expect that everybody's doing the same, that
Yeah,
nobody's being disrespectful when they look to the right or the left, because they probably have two screen monitors and
without
one
a doubt.
has this and one has their mediation statement or one has facts or whatever it is. But inherent in that is a bias that they're not looking at me. I can't see their language. I don't know what they're saying. So you've got
But
to
you can see
read
but you
facial
can see
language.
you can see their facial expressions better, couldn't you? Can't
You
you?
can see your facial expressions better, but there's a lot to be said for body language. It's very
Yeah,
different. I've
yeah,
learned it, and not everybody has a poker face. Very few people have poker faces.
sure,
But they also start to distort their face, and sometimes it can be misread, and it's just because they're tired of looking at the stupid dot. Like
yeah.
literally, it has nothing to do with what's going on, but they're staring and staring and staring, and at some point they just start to look different.
Is your success rate less with virtual or just
No,
about the same?
somebody asked me that. No, my success rate, I've never bothered to really look at it and say, where does the needle move? What I would say differently is this: there are one or two cases that I have settled that I know the only reason they got settled was because I was in person.
In person? Yeah, okay,
Those would not have settled because I was able to connect with somebody. I was able to just do things differently. And there were a few where maybe they would have eventually settled, but they wouldn't have settled as expeditiously or as effectively. And I
sure.
really believe that being in person made the difference.
And Beyonce, like you're nodding yes when she was saying that about in person. You mostly do in person?
Uh, Unfortunately, the answer is no, but I prefer in person. And to your last question to Leslie, I personally have noticed less of a success rate on remote mediation than in person. Most of my clients and matters to deal with businesses, and I just feel like when my client representatives have to invest a whole day away from their work computer, that they are more vested in never being ever bothered again and
That's a good
willing to
point.
consider mediation. Resolving this in mediation. Whereas otherwise, if they can do work and other things, the motion sometimes that or the momentum developed during mediation sessions going back and forth, I feel like sometimes is lost when they're able to all of a sudden, oh, I got to work on this other presentation.
Sure, sure.
I really, really prefer, in my experience, in-person mediation.
No,
It's interesting because the trend that we're seeing at AAA ICDR for our mediations is more of them are going virtual. That's the trend right now,
Right.
for various reasons, but that seems to be the trend.
Well, and it's cheaper, right? And if you're running a business, you don't want to, and you're in New York with the mediations in Denver, you don't want to spend the money to send somebody for a whole day and a half if you include travel.
Yep.
But I think that's short-sighted because that money invested really puts you in a different perspective, saying, okay, the company sent me here. Maybe I should
Sure.
really consider how to resolve this.
That makes sense.
I
And when
agree. I think those are good points. I agree with all of them.
same, and when you're in person, does food help?
Uh, yes,
Without it.
and I say, yeah, I'm smirking because sometimes lack of food also encourages people to get this over with
They
to
get
get dinner.
cranky. They get
Yeah.
cranky. I have an expression. It's mine. I got a copy it right one day. Never underestimate the value of a well-placed cookie.
Yeah, yeah. I
I
mean,
think.
as Leslie knows, in our office
Yeah.
in Manhattan, we serve food now, and it seems to be effective. It's for
And
people.
he's got good snacks.
Yes, we have great snacks. We have great snacks. So let me see what slide we're on. Do we cover the content, how to craft
I
and
think
effect?
we've covered
Yep.
this.
Okay.
Let me add just
Okay.
one thing
Yeah,
though.
absolutely.
And this goes to previous conversations we had today. One of the things that I think, if you're going to do an opening statement, I would encourage lawyers to think about actually presenting something as an exhibit or a demonstrative exhibit. One of the best opening statement scenarios that I've been involved in as a young attorney was when we were involved in the patent litigation, and the science and the technology was really hard to explain and probably to show to a jury. But the mediation gave us an opportunity to essentially show graphically and through a video what we think the technology was. And it was really effective for getting everybody to understand each other's respective understanding or positions regarding the technology that was subject of the patent. So and that goes to the format and the messaging issue, but also the tone, body language, and word choices. Obviously, be professional and avoid looking antagonistic, and everything else is kind of similar to what you would do for an opening when it comes to language, body language, and tone in trial.
Sure, absolutely, absolutely. So I think beyond like this is still you, I think.
I think so.
Oh yeah, it is. Okay, so what to expect during the shuttle diplomacy? And Leslie, I think I heard you say you're not a big fan.
Well, let me for 2 seconds come. It's not that I'm not a fan of shuttle diplomacy. When you're in private rooms, that's what you end up
That's what
doing.
you have to do.
Is
Yeah,
you have to. My point is there's a point at which it's a little silly. I'm basically regurgitating
yeah,
as opposed to analyzing. There's a point at which you get to, there are certain arguments that it's actually better for them to have a conversation about, a legal issue or something. It's just more effective than me trying to go, okay, let me learn all these facts and run across the hall, because you've raised something new. So
sure.
it should never be pure shuttle. You sometimes get to the point that you're taking offers and, we've passed, we've vetted all the issues. We've talked about all the risks and rewards and ups and downs, and now we're just doing numbers. That's all fine. But there is a point at which I think, not in every mediation, but sometimes I just say to the lawyers, I think it'd just be easier to have a conversation. Otherwise, I'm going to try to understand a point that's so steeped in the facts that there's only so much I know as a mediator, because I'm just never going to know it as well as the litigators.
Got it.
Yeah, and I would say there've been times when we started without the joint session at all, Leslie,
Yeah.
and that usually happens for me when I have an adversary on the other side that refuses prior to mediation to have any discussions about potential settlement. And whereas my side may have issued a pretty good faith, thoughtful offer of settlement before mediation,
Right.
when I have an opposing party and opposing attorney like that, I almost always ask the mediator, hey, can you just go to their side and let them know that we can't really start without understanding where their position is. And most mediators have been helpful in doing that. This slide's pretty self-explanatory about what happens in shuttle diplomacy. So what I want to focus on is what Leslie kind of talked about, which is there are plenty of situations where a mediator came to me and asked me a question, and I started explaining or showing documents that weren't part of the statement. And it turns out we just pause, we look at each other, we go, hey, let me explain to opposing counsel, and then we step out, leave our client in their respective rooms, and I have a frank discussion with the mediator present, so that mediator, he or she, can understand what I'm expressing, what I'm showing, and it's really effective. So I would not hesitate encouraging attorneys to, in the middle of the shell diplomacy, to break it up and say, okay, I think now's the time for maybe the parties to talk, then go back to shell diplomacy, or maybe, for me to explain an exhibit to opposing counsel. I find that to be very useful.
Sure, absolutely. Okay. This was going to be Liz, the mediation session, exploring the strengths and weaknesses. So I'll turn to both of you guys.
Okay. So, part of what you're getting from a mediator or a good mediator is essentially some level of early case, evaluation, early neutral evaluation. Part of what my job is supposed to be is going into each room and pointing out where they're wrong or where they have risk. Or sometimes it's having a conversation because sometimes the lawyer really doesn't understand the risk or wants to talk it through. Sometimes it's the lawyer that gets it and it's not the client. And I'll have lawyers say to me, it isn't me. My client's got to hear it from somebody else. I keep telling them there's a problem here, or I keep telling them there's a risk. And it's a mistake when you get too much pushback, because I'll always say, I'm not the judge. I don't talk to the judge. But I'm taking my 30 years experience or familiarity with this or the kinds of cases, and I'm just sharing something with you. And I want you to think about it because you may be missing something here. I'm not 100% right, but that's really great that you think you've got a slam dunk. And I know as a litigator, I've won cases I should have lost, and I lost cases I should have won. There's no such thing as a slam dunk. And part of this is being able to have somebody else look at your case and tell you where there's a problem so you can make a decision. Are you really right that the facts fit the law? Are you really going, they always say, oh, I'm going to make a motion for a dispositive motion and it's going to cost 10 grand. And I'm like, really? You can get that in writing for your client? It's never going to cost 10 grand. Where did you come up with that number? You're telling your client that, and I don't do it in a dismissive way. I make it a joke, to be honest. I'll say to them, there is no way, you're going to get opposition. You're going to have to put in papers. It's not going to be as simple as you think. And then the court may not even grant it. Let's really talk about the fact that, are you really seriously thinking you're going to get rid of this on summary judgment or a motion to dismiss or whatever it is when we have all of these facts out there?
Sure.
Yeah, I really like it when a mediator actually expresses their opinion. It is probably, from a party and litigator perspective, probably the first time you'll have a non-interested party kind of give their impressions, and I value that. And when mediators aren't willing to kind of at least talk frankly with me, that I may never use them again, frankly. Yeah.
So evaluate, facilitate. You like the evaluation at the beginning. Okay. And Leslie, as a mediator,
look, I'm facilitative, but it comes with evaluation. So there's a right moment where the right moment is, depending on the mediation. But, I had one the other day. I got on a pre-mediation call with someone and he's giving me all the reasons why. And I said to him, all I can tell you is you may have a lot of different responses to this. And I'm not telling you that I'm not an arbitrator here. I'm not accepting what they said verbatim. I read the other side's papers. I've done enough of this. And I went, oh, that sounds terrible. I mean, I'm paraphrasing what I said, but I literally said to him, where there's smoke, there's fire. So you're going to explain all of this away. I'm telling you, I read these papers. I'm a former federal law clerk. If I was reading these papers with my judge there, yes, there are answers, but there's a lot of stuff going on here that just doesn't sit right with me. How much do you think you can really explain away? You really, you're going to counter every single point. And yes, they're argumentative and they're raising it in an advocacy way, but facts are still facts.
Sure.
And that's a problem.
Well, I like how you said you blend it, kind of evaluate and facilitate. I have a mediator in New York, and Leslie, I think you know who he is. He says on his resume, it says, I facilitate in the morning, evaluate in the evening.
God.
And I guess some people like that. I don't know. But I kind of prefer your approach of kind of blending it when it's necessary. And beyond SOC, it seems like you kind of like that approach, but more evaluation at the beginning.
I like evaluation throughout, but but the beginning is real nice. More importantly, I love to hear the valuation in front of the client in our little room.
Sure.
And then, because usually when the mediator does a great job of evaluating that their perspective, when they leave for shuttle diplomacy, we have a lot of discussion processing what we just heard, and I find it helpful.
Sure,
I
absolutely.
also will leave sides with what I call homework. I leave a room and I'll say to them, look, I'm gonna go talk to them about blank. I want you to think about the 3 things I just said, or by the way, could you please make sure you get a hold of someone in your accounting department because I've asked you questions about this. Maybe you could run that down for me. And I want you to think about why. Sometimes I don't have anything for them to be left with, but sometimes I will do so. And sometimes something comes up in the other room and I may have to leave and say, I'm gonna be right back. I'm gonna go back in and go, look, I had a question raised. I'm not ready to come back to you, but I want
Sure.
you to work on this so that you're ready for me when I come back, because I'm gonna need an answer to this. They're gonna need an answer to this, and I'm gonna need an answer to this because it's gonna be an impediment, or it could be a key to a door.
Yep, absolutely. So, okay. Okay, Beyonsock, this is you revisiting the following risk analysis.
Yeah, and these are good acronyms just to help you process a good way for litigators to talk to their clients prior to mediation or during mediation in hopes of understanding your client's goals through the mediation. And obviously, the best alternative to negotiate settlement is going to trial and winning. But attorneys should have a frank discussion of what that really means. That means there's a lot, typically, obviously outside the contingency kind of scenario, there's a lot of cost associated with that. Cash flow, immediately paying your attorneys to get prepared for trial. Then in any situation, regardless, even if it is a contingency, a lot of time devoted outside of, for my clients, their businesses, because usually I'm representing businesses, basically focus instead on revenue, marketing, operations. They're focusing on me. And as much as I like them, they may not like spending that much time with me. The worst case alternative is also, hey, if we don't settle today, we go to trial and you lose. And here is is the worst case scenario. Not only this judgment here, you also face basically the potential fee shifting if there's a contract in play that allows for the winning party to get their attorney's fees. Now you're not only subjected to a judgment for the damages, but it may be hundreds of thousands of dollars after several years of fees from the other side that you got to pay. So always consider the likely alternative to negotiate settlement, meaning let's not talk about the best, not talk about the worst. I shouldn't say not focus. You should always talk about them, but then really focus on, okay, here's what I think is likely to happen. And that's what what your client and you should consider, not just the best and worst case scenario, because that is probably the prime area or the key zone where you can try to reach a compromise if you think the other side will think likely as well.
Sure,
Because if you're thinking of the best case scenario, the other side's likely thinking of the worst case scenario and vice versa.
absolutely.
And let's stay on that for just a
Oh,
second.
sure. Yep. Hold on one second.
They'll blend a little bit, but sometimes, and mediations come in all different points in a case. So you could be at the start of a case where you have to think about your discovery process that hasn't unfolded. You could be post-discovery, but not yet through depths. You could be at dispositive motion stage. You could be submitted dispositive motion. You could be in appeal process, all of that. So understanding the procedural context is really important when we go through all of these things. The other thing is sometimes I find that people have misunderstood their procedural process. I'll have one side say to me, yeah, well, I'm just going to be taking these depositions and I'll just, I got to take, 3 more depositions and I'll go in and I'm talking to the other side. And to me, that's sort of fair. I don't identify the people, but I'll say, oh, you're not done with deps. And the other side will go, what are you talking about? The order's done. They can't take any more depths.
Yeah.
The deadline's there. And so, sometimes it's also educating them on where they are in the case. And sometimes counsel's really misunderstood procedurally what they think they can do and where they are.
Sure.
Obviously, very careful that I'm not giving away a strategy or, I'll always say, is that something they should be aware of? Yes. Is it something I can share? Absolutely. I'm very, very careful every time I leave a room that nothing is being shared that shouldn't be. You know, and by way of example, for, you know, to touch on that, I always say to people, you know your case better than I do. I
Yeah.
have a handle, I've read the papers, I know as much as I know. If during the course of our private caucus, you believe you have shared something that the other side does not yet know, and that you are not yet ready for me to share, and you may never be ready for me to share, before I leave the room, I want you to identify it for me. I'll do my best to flag it. You know, so sometimes they'll say, well, you know, we need to talk about this insurance policy, but we're not ready to talk about it yet. Please don't raise it with them. It's very clear. But before I leave the room, I will say, it's okay to share this. It's okay to share that. Have you told me anything that I cannot share? Because I don't want to be responsible for saying something in the other room that should not have been shared as of yet, and that I misunderstood should be shared. And that the burden is on the attorneys to keep track of it, even though I really try to be very careful and work with it along those lines. But that's part of educating the other side. And sometimes there's an imbalance in the ability of the lawyers between the two rooms.
Sure. Oh, God, yeah.
Okay.
Now, to your point about, you know, well, the thing is coming up a lot. We hear a lot nowadays, our mead, whatever. Okay.
You know, I have views on this.
Yeah, I know you do. From what you just said, you would never go from a mediator to an arbitrator. Even if the parties really wanted you to do it,
No,
even if
I
you
won't
signed
do it.
away.
I think it's dangerous. I will go as if I'm your arbitrator,
Yeah,
and you want me to mediate, no problem, because I haven't gone behind the curtain.
exactly.
The minute I am mediating, I do not believe I can arbitrate for the following reason. I don't care if they tell me, I mean, and that's assuming the mediations happen, not like we agreed to mediate, you know, they shared some statements and we haven't started the process, different story. But once I'm in
Different
the
story, yeah.
room, even if they say they're going to waive, and even if they say they consent, when I go ahead and I find for one side off the other, I am always concerned about them saying, you know what? She knew, she misunderstood, she did X, Y, and Z, and that's why she found for them. And then they challenge the award. I want the award to have integrity and not be subject to challenge. And I worry that that release or that agreement might not hold up.
But I agree with you, but for some reason it's becoming acceptable in some areas of our world, but not AAA's position is still, we're not a big fan of it, but it's the party's process. Beyond such, would you ever do it, have the mediator and then all of a sudden switch to an arbitration if the mediation failed?
No, I've never personally done an ARB mead, but I would consider it. And
Yeah.
here's why I would consider it is often many of my mediations I've had, and even in bench trials, I've had judges or the arbitrator make off comments like, "I can't believe you guys aren't settling," you know, you know, because somebody's going to pay a lot of money here, and I'm sitting there going, you know, after they heard our presentation, maybe it would be great to go into mediation with these people because they've already kind of formed an opinion, especially
Sure.
the judges and during my bench trials. Some of the comments, you know, if it weren't for the fact that there's a lot at issue,
Yeah.
they'd be humorous because they sit there and they'll literally look at a party, a witness, a counsel, and say, "I can't believe you're wasting my time today." Now,
Yeah.
arbitrators won't say that. Judges
Yeah.
have the privilege of saying that.
Yes.
They do.
But the message is usually the similar. So I'd consider it. I personally have not done it though.
Sure.
But I would do it that way. That way is 100% okay for me because I'm the arbitrator and then you're taking me to mediation. But think about it, if I've been mediating and now you've shared private information and now you want me to arbitrate. And some of what's been shared might not otherwise be a part of a record with me. So I've heard that, I'll make it up, your client is financially insolvent. Or there's bodies buried somewhere that the other side doesn't know about. How do I become unbiased or you know, I can't unhear the bell. That's
Yeah.
that concerns
Understand.
me,
Yeah.
is going the
Understand.
other way.
Well, we have Liz joining us now.
This is
Liz,
almost in time for her slides.
yes, and yes,
I was just gonna say, am I here for the term sheet stage? Because that's what held me up
Yes,
unexpectedly.
Yeah,
pretty
well, we
much
have one more with Beyond Suck, and then we're going to go to you. But did you settle your mediation?
I did, and my sincerest apologies. We agreed to take a break from 2:45 to 4, and then we got to the deal, and we'll talk about why I had to see that through and could
Okay.
not break. Go ahead.
Beyonce, I think you got this last one.
Yeah, and actually, Liz can jump in on this one as well because I think it overlaps to what she's basically just done. So if you don't resolve this, you're depending on whether the mediation was in conjunction with litigation or arbitration, you go back to litigation process and prepare for trial, or you go back to arbitration and prepare for a hearing. However, that doesn't need to be the end of it. I've had plenty of mediations where it didn't succeed, but the parties go their own way. But I talk to the mediator afterwards and say, hey, we ended the mediation this way. Can you go back and see if they can, give them some time and think about it? And I've had mediators over weeks after a mediation session ended without success, through email or through phone call separately, still work the shuttle diplomacy and has settled. So,
Nice.
I think it's great. If you don't settle, we already talked about the best case, worst case, and likely scenarios. That's what you should consider. Litigation and I consider arbitration a part of subset of litigation is always expensive. And even my most principled clients who feel like they have to fight this to the end for a principle they believe in, they've all said the same thing, which is emotionally it was probably more challenging than they ever expected. And even when I get a great result for them at trial or hearing, they never want to see me again. So, I feel like I've done some public service by reducing litigation in the future, but it's a toll, and people need to consider that and understand there's emotional value at resolving through mediation instead of going through through the arbitration or through trial.
Sure.
And the only thing I'd add, and then I think, let's bring up the wrapper, if you would,
Yep.
is I also add to them sometimes what I call the lost business opportunity, which is if you're sitting here trying this case, put aside you've quantified the cost of litigation, you've quantified maybe your risk, you've given a percentage to your, win-loss ratio. You're sitting there in depths, discovery, hearings, trial. You're not running your business, and your employees aren't running your business. That has a value. It has to be, so I get them to a certain point, and then that's the piece that I said, okay, so you're X dollars apart. You mean to tell me that doesn't have a business value to you, separate apart from everything else?
Mhm.
Think about that. That works when you're close enough, and close enough varies. Close enough could be $500,000 in one case and $5,000 in another.
Yeah. So I
Liz,
appreciate that. And I'm sorry again to join so late. One thing I will say about the day of a mediation and is representative of what I just experienced is that there's a momentum to the day, right? And so I often say, like, I don't take breaks, we don't take breaks. I mean, parties will take breaks, but I don't take a break. I go from one room to the other, because this momentum builds throughout the day. And some mediators will tell you that 50% of cases settle the day of. I think in my experience, it's a lot more that settle the day of if people stay committed and keep at it, usually till very late at night. And there's a reason, I tell people I don't want to let you go or I want to keep at it, is because this momentum that builds. And once that momentum leaves, even though I do my best, and every mediator should do their best to keep us sort of leave off as best as possible, leave the door open so that the mediator can call, nobody should walk away from the table. I'll ask people to stay where we are. So for instance, if you're at, $1 million and the other side's at $500,000, like, don't take the money off the table, don't raise your demand, like, let's keep things status quo, let's keep talking and so on, because you don't want to close the door for all the reasons that Beyonce and Leslie just said, the emotional toll, the time cost. Once you're in litigation mode, you're in litigation mode. But there is this momentum that builds. And I really fight with people to stay, to stick it out, to get to the deal, because after that day, it starts to fall apart. And all the work that the mediator's done, all the work that counsel's done becomes totally different. You undo the work, right? People start saying, oh, I didn't, I go back to where I felt strongly about this. I don't buy what the mediator said. I don't care. So it's important to try to settle the day of, to the extent you can, or soon thereafter. But to Beyonce's point, sometimes it just can't be done. I have a case that I worked on for a year. I just kept calling, just kept asking, just kept calling. And then finally there was an opening. So keep the door open as best as possible, because all the work you spent on the day of the mediation. You don't want it to be lost and for nothing, missed opportunity.
Absolutely. Now, Liz, it looks like your mediation was done in virtual. Looks like you're at home. Is that correct? We
Yes, yes.
we went over virtual versus in person. What do you like better? I think you like in person, like our two other colleagues.
Yes, I like in person better. Virtual it works, but it's harder usually. It's honestly very rare that I'm done at this time. That's why I said to the parties, we'll take a break so that I could join us. Because usually we're not done till 7, 8, 9 o'clock virtually because people are more distracted. Whereas in person, it tends to finish a little bit earlier and
Yeah.
people are very focused on the process. There's also something to the tech because sometimes people don't think you're looking at them or they hear things differently or they're alone in their room and something's going on at home or
We were talking about that very thing. Leslie brought that
yeah,
up.
there's a distraction, like you don't know what's happening and the vibe gets off. So I much prefer in person.
Absolutely. Now, we mentioned a couple of times, guys, about judges. Beyonce, I'm going to turn to you about judges. Do you like mediators or judges or not? Or doesn't matter?
This is going to sound extremely personal for me. I like judges that have appeared before in trial because so that's one scenario. When they have now become mediators or arbitrators, I gravitate towards them because I know how they think, and I instantly, hopefully, have some credibility with them because they've seen me perform in trial, so they understand at least on the other side. And you know, I finally look my age, but for most of my 26 years that I've been practicing, I've always worried that opposing counsel thought that I was a lot younger and less experienced. So it's nice to have a judge to go, hey, remember, in joint sections, hey, it's great seeing you, since 3 years ago or whatever, and
Yeah.
and that usually puts everybody on a more level playing ground, especially if I'm dealing with counsel who's more senior to me.
Sure.
So I prefer judges to that end. Beyond that, the most critical thing that I think of, and it's not limited to judges, is their qualifications on the subject of the mediation.
Sure.
So if it's a patent issue, I prefer somebody with patent litigation experience. If
Got
it's
it.
a construction issue, especially, so intellectual property for me, construction and employment cases, I prefer somebody with substantive expertise, legal expertise in that area, regardless of whether they're former judges or private practitioners.
Absolutely. Leslie and Liz, you guys feel the same way, sort of, about judges?
I don't.
Okay.
Leslie, I don't know. I'll let you go last, Leslie. I don't. It depends. I mean, it's the rare instance. A successful mediator has to have the process skill too, not just the subject matter. I agree with Beyonce. Subject matter is important, but not all judges are good mediators, just like not all arbitrators are good mediators, and not all mediators are good arbitrators. It's the skill set that to me is very different. And so when somebody is a judge, in my experience, right, they had the ability to close deals or to persuade parties in a different way by what we call the power of the robe, right? The power of the robe, just having the robe, being the decision maker, being the judge, sitting up higher than everybody, whatever it is, you tended to do what the judge said because if you didn't, there might be some consequence or something might happen down the road or they'll be deciding the case. And so at the end of the day, that power is gone, right? So you have to have a different way to persuade. And so I'm always concerned. Judges say, oh, I settled so many cases when I was on the bench, and then they get into mediation private and they're not settling. It's because it's a different skill set to persuade people, right? You don't have that authority. Leslie?
Sure.
I think
Leslie.
I'm pretty much on the same page with Liz. So I think there's two things. Judges and there are exceptions. So this is not wholesale, and it's not wholesale in any respect, but judges were directive. That's what they were. That's why they can be good arbitrators. And even then, sometimes they have to learn that. But mediation is a skill set. And I don't think people really appreciate it. I had someone recently reach out to me and say, hey, I'm retiring as a senior partner at a law firm. Somebody told me I should just be mediating. I said, great, are you going to get trained? Because there is an art form to doing this. There's things you can do and you can't do. There's ways to do this. And you could be practicing for 40 years and you may stink as a mediator because it's just not experience and knowing the law. There's so much more that goes into it. Those are all part of it. And I think sometimes there's a lack of appreciation of there really is, you got to know how to do it, and the way to do it and be able to pivot based upon different cases.
Sure, and a lot of arbitrators I hear from, I know, Liz, when you worked with the institutions like I do right now, a lot of arbitrators think they can mediate. It's like, really? So, but guys, we are at the top of the hour. I want to thank you, all three of you. You guys are terrific as usual, and this concludes our webinar. Thank you for joining in another entertaining yet educational production of Financial Poise. We look for financial webinars wherever better continuing education webinars are sold. And we hope you will join us for the next webinar in the Alternative Dispute Resolution series. It is, like I told you at the beginning, number 3, Preparing for an Arbitration. That premieres June 24th. And then the final one is Handling the Arbitration with this great group. And that premieres July 22nd. So I want to thank you guys again, and goodbye to our audience. Thanks.
Thank you, everybody. Thanks so much.